Welcome to FYIVT, your inside source for news and in-depth analysis on what's really happening in Vermont. We want to start by saying thank you to all our listeners and supporters. Your continued encouragement fuels our mission to dig deeper and bring light to critical issues that shape our communities. We couldn't do this without you. Today, we're diving into our article titled, Legislating by Lawsuit, Vermont's Unstable Approach to Governance. In recent years, Vermont's legislature has passed several laws that appear to invite court intervention as a primary means of enforcement. This shifts responsibility away from lawmakers and onto the judiciary. But does relying on lawsuits really solve the problem or just create new ones? This approach raises significant questions about governance, particularly when Vermont's courts are already overburdened. Even more concerning, it creates an unpredictable business environment that fosters economic instability for state stakeholders and taxpayers alike. Let's take a closer look at three key examples where Vermont's legislature has relied on the courts to enforce its goals, creating uncertainty and inviting unnecessary complexity. The roots of the trend, Act 60. We begin with Act 60, Vermont's controversial school funding law. It was passed in response to the 1997 Vermont Supreme Court ruling in Brigham v. State, which found that the state's education funding system violated the Vermont Constitution's guarantee of equal access to education. Rather than creating a direct and practical solution, the legislature set up a framework where legal challenges were inevitable. By requiring wealthier towns to subsidize poorer districts, Act 60 invited disputes over what constitutes equal access and how much funding is truly fair. In practice, this left the courts to define the contours of equitable funding, pushing tough decisions away from lawmakers. It's like setting a fire and handing someone else the extinguisher. Legislators created the problem, but left the courts to clean it up. In short, Act 60 left Vermont taxpayers and school districts in a state of perpetual uncertainty, where fairness was debated in court rather than settled in law. A climate of uncertainty, the Global Warming Solutions Act. Next, we turn to the Global Warming Solutions Act, or GWSA. Passed in 2020, it's a cornerstone of Vermont's ambitious climate policy. The act sets strict benchmarks for cutting greenhouse gas emissions and holds the state accountable for meeting them. But instead of ensuring compliance through government oversight, the GWSA relies on private citizens to sue the state if emissions targets aren't met. This places enforcement entirely in the hands of the courts. Here's the problem. This litigation-first approach creates economic uncertainty for Vermont businesses and taxpayers. Without clear regulations or predictable outcomes, businesses are left navigating a minefield of potential lawsuits. How can companies plan for the future when they don't know whether compliance with state goals might lead to court battles? This is yet another example of Vermont legislating by lawsuit. The legislature sets ambitious goals, but avoids directly confronting the economic costs or political backlash of enforcement. If lawsuits force the state to act, legislators can claim their hands were tied. Convenient, isn't it? Data privacy, a new frontier of litigation. Our final example is Vermont's Comprehensive Data Privacy Bill, passed in May 2024 and later vetoed by Governor Phil Scott. The bill aimed to protect consumers by allowing them to sue companies not only for data breaches, but for any violation of data privacy rights, such as improper collection or sale of personal information. While many states have laws allowing lawsuits after data breaches, Vermont's law would have gone further. It opened the door to litigation over broader data misuse, leaving businesses unsure of where the boundaries truly lay. Had the bill been signed into law, companies processing more than 100,000 Vermont consumer records annually could have faced lawsuits for even minor infractions. This creates an unstable and unpredictable business environment. Instead of giving companies clear rules to follow, the law would have left them guessing about what might trigger litigation. The ripple effect is damaging. Hesitation to invest, slower economic growth, and higher costs for everyone, including Vermont taxpayers. Once again, the legislature crafted a law that invited lawsuits rather than offering solid, predictable rules. The courts would have been burdened with sorting out the specifics, while lawmakers sat back, appearing proactive without having to manage the fallout. The bigger picture, courts as the legislature's enforcer. So what's the impact of all this? Vermont's courts are already overburdened, struggling with case backlogs and delays. Yet the legislature continues to offload enforcement to the judiciary. Each new law that invites litigation shifts more responsibility onto the court system, which is ill-equipped to handle the load. But the consequences go beyond the judiciary. This approach undermines economic stability for Vermont businesses and residents. When laws rely on lawsuits for enforcement, they create a climate of unpredictability. Businesses need clear, consistent rules to operate efficiently, invest confidently, and grow. Without that stability, Vermont risks slowing its economy and harming the very people these laws aim to protect. Closing thoughts. Time for accountability. It's time to ask an important question. Why is Vermont's legislature so comfortable hiding behind the courts? Whether it's Act 60, the GWSA, or the Data Privacy Bill, lawmakers have repeatedly handed tough decisions to the judiciary, avoiding direct accountability for their policies. This tactic allows legislators to claim they're addressing big issues like education funding, climate change, and consumer privacy, without taking responsibility for the economic and practical consequences. And when the courts enforce these laws in ways that disrupt businesses or burden taxpayers, the legislature can simply point fingers elsewhere. Vermont deserves better. Predictable laws, clear regulatory frameworks, and direct legislative accountability are essential for good governance. It's time for lawmakers to stop legislating by lawsuit and start crafting solutions that provide stability for the courts, for businesses, and for Vermont residents. Only then can we move forward on solid ground. Thank you for listening to this episode of FYIVT. To read the full article and explore more on what's happening in Vermont and how the state works, visit us at FYIVT.com. We appreciate your support and look forward to continuing to bring you important perspectives on Vermont's most pressing issues. Until next time.